Indeed, and Kethi Kilonzo is with us tonight. Karibu sana.
Thank you.
I don't know where should I start, from your performance or from your stronghold that is low. But let me be fair with you and start with the stronghold and we finish with the performance later on.
Thank you.
The Supreme Court decision was out obviously weeks ago, but the details came out this Tuesday. Did it satisfy you?
Well, it's not about me, James. Elections, again, I keep saying, are not about candidates. It wasn't about the people who are contesting. It's about the people who registered to vote and queued for 6 hours in order to exercise their mandate. The question is this: where did we come from? In 2007, when the immediate former Prime Minister lost, as declared by the ECK, he said that he didn't have confidence in the judiciary. And as a result of those botched presidential election results, we saw an overhaul in the complete legal system in this country, the Constitution. 256 laws, Parliament, we now have Senate and Parliament. The executive has changed, the judiciary changed. The question is, after that decision, in 2013, are Kenyans satisfied that the Supreme Court is an option in the political contest for the seat of president?
And if you've asked that question, then I'll ask you to answer it. What's the answer to that question? Do you think Kenyans are satisfied in the end that if we come to such a situation and such a scenario in 2017 or whatever after that, will Kenyans think the Supreme Court is the place to go?
I can't speak for myself, but I can speak for my clients. They're not satisfied that the court met the expectations of Kenyans when they stood in line at the referendum to vote for this constitution.
What are some of the things though, that you'd point out that your clients would say we're not satisfied with? A few things that didn't happen. Most important for you and your client was the registration of voters,
Yes.
The Green Book, and how people were registered.
Yes.
That was central for your case. What are you not satisfied with that?
Well, let me start from the Constitution, because it is the bedrock of everything. The Constitution says that an election, whatever election method you choose, it has to be simple, accurate, verifiable, transparent, free and fair, and accountable and efficient. The Elections Act states that any election must be conducted in accordance with the law. Yes? And if it is not, you have to ask, did that breach of the law affect the result? What was the evidence before the court? The registration of voters through the biometric kits failed. The identification of voters through the EVID failed. The electronic transmission of results failed. It's a fact. The court, of its own motion, stated that the Director of Public Prosecutions should investigate the IEBC and prosecute the people involved. The question is this: if the court is satisfied, and you know, to send somebody, to say somebody should be prosecuted, you're saying you have no doubt that a criminal offense did occur. What more evidence did they require that this election was not conducted in accordance with the law?
They would argue
Yes.
that, well, there was some discrepancies in their ruling that,
Yes.
listen, we're not saying that this election, and one of the lines, not that this election was didn't have any abnormalities, but it was not in such a magnitude that it would warrant, you know, a re-election or something.
True. And that is what I said about electronic versus manual systems. The question is this, James: why did Kenyans invest 9 billion, and we are still paying for it? 9 billion for systems that didn't work. But that wasn't the only thing. There's this question of the register, and I'll keep coming back to it.
The Green Book.
The Green Book. No. The Green Book is not a register. There's only one register recognized in the law, and it's the principal register. The court itself stated that there were anomalies between the number of registered voters who voted and the number of registered voters that IEBC declared as having voted. And they did not state what was the anomaly. What they simply stated was it didn't affect the result. The question is this: the court of its own motion on the 25th of March 2013 says we are going to conduct a scrutiny. The things we are going to scrutinize are Form 34 and Form 36. And what are we looking for? One, we're looking for who were the number of registered voters indicated in Form 34. Was that question answered? No. You know why? Because IEBC did not produce all the Form 34s. Form 36 did, could you verify the total votes cast from Form 36? Was that question answered? No. You know why? 75 out of 291, 25% of Form 36s were missing from the court record. And I will challenge anyone who says that this is a proper judgment to go into that judgment and tell Kenyans how many registered voters voted in the presidential election according to the Supreme Court. How many were they? So that you can answer the question whether the difference was significant. How can you answer it if you don't have a figure? How? And when they ordered scrutiny, this is what the court said. It said, in determining who the number of registered voters are, the court will compare Form 34 and the electronic register provided by IEBC. What did they eventually do? They allowed IEBC to bring green books. Green books that no one knew existed before the presidential petition. Did you know there was something called a green book?
I had it from you. But
allow me. On 4th of March 2013, Ahmed Isaac, the chairman, addressed Kenyans. Did you hear him tell anyone, if you don't find your name in the register, ask for the green book? Huh? And the court itself said that the green book is not provided for in law. And what do they say? It is not apparent that it's required to be provided in law. Is that a court of law, James, or a court of logic? And the question is, what did Kenyans want when they constituted the Supreme Court? Is it 2013 elections, or did they want elections that are conducted in accordance with the law for generations to come? What did Kenyans want? And did they get what they bargained for?
So the question then that arises from all these questions that you're raising, and the Supreme Court tries to give answers, and the logic and the reasoning, is that in the end, were you supposed to give evidence that was beyond reasonable doubt or probable cause?
That's true. And I'll go back to the Constitution. This is what the court said. You remember we produced a video from Nyeri and Bomet, in which the presidential results declared at the county were different from the ones declared in Bomas. You recall. And that evidence is mentioned in the judgment, and it was not challenged at all. So as we speak today, you can say as a fact the results were changed. The question is this: what degree of irregularity do you require in order for you to steal an election legally or to manipulate an election? You understand what I'm saying? Yeah. What degree? How much is it? Because the Constitution says simple, accurate, verifiable, transparent, accountable. What did the court say? It says you have to show major breach of a law. I challenge you to find me in the law and in any jurisdiction the use of major breach of electoral law. It talked about profound irregularity, profound. Huh? It talked about gravely impeach, gravely, you know, grave, then leave impeach. It also talked about, there was something else, that you have to show that the election is devoid of merit. Where did these standards come from? You know what you have said, what the Supreme Court has said is win at all costs. Yes, win at all costs.
But to give when they're coming from this again, the judgment, and talk about to scrutinize the IEBC, scrutinize the BVR kids, what are the parameters for this scrutiny? Do you know?
Well, the court set its own scrutiny. Are you talking about the investigation?
Yes.
I'll let the DPP do its work, James. But for me, the most important thing is this, that we had post-election violence in 2007 because of the presidential elections. We completely changed the way this country looks because of the presidential elections. After we are done with this presidential election dispute, what have we achieved as a country? As a country, because at the end of the day, the Constitution belongs to Kenyans. You understand? And this Constitution should take us the next 50 or 100 years. Have we gone a step further, or have we gone a step backward?
So in your mind and in your client's mind then, the question then begs, where did these elections go wrong? At what point did it go wrong? Was it in the registration? Was it during the tallying of votes? Where did it just go wrong?
Well, there were quite a number of irregularities, if you ask me, and according to my client's evidence. But you know, there's another aspect to this, and the aspect is this, that you should be able to have recourse. If somebody steals your goat, you should be able to have recourse. Why do people resort to mob justice, James? They find somebody who has stolen, they take a tire and they burn him. Why? Because for some reason they have no faith in the criminal justice system. Isn't that a fact? If people saw efficient and proper prosecution of suspects, you would not have mob justice. The Supreme Court had its own role to play. The IEBC had its own role to play. In fact, if you ask me, the role of the Supreme Court was only second to the referendum, because we went to the Supreme Court because of the botched presidential election petition, election results in 2007. Okay, and I'll leave it to you. You're in media, you have the tools. Walk out to the streets, speak to Kenyans, ask them, do you have faith that in 2017, this is a forum where we can resolve another presidential election dispute if there is any?
So are you saying the Supreme Court failed?
Yes, it did. It didn't fail because it did not dismiss the petitions. It failed because the reasons it has given to uphold the election do not meet the standards of the Constitution, do not meet the standards of our law. In fact, the Court of Appeal has generated far better jurisprudence on elections. The High Court of Kenya has far much better jurisprudence on election than the Supreme Court.
All right. Fair enough. I'll need to take care from your stronghold a bit, and I have lots of questions coming on Twitter. Yeah. And people asking, I mean, ever since your performance at the Supreme Court, if I could call that, how's your life been ever since that?
It hasn't changed.
How's that?
It wouldn't change.
Because it said that you did very well. Do you think you did very well in presenting your client and representing their issues in court?
What I can say is I did my best. Within the challenges and the time constraints, I did my best, James.
Should we? One of the articles that I've seen and I've gone through, someone is talking about the legal limits that the Supreme Court has in trying to process this petition, and talked about the time was too little, or it was not considerate enough. Do you think that's something that we should change or we should look into?
No, not at all. After the 14 days, the Supreme Court delivered its decision and it said, we are upholding the election. And they asked for 14 more days to give their reasons. Did you hear anyone complain, including the clients from all parts, from all sides, the advocates of Kenyans? Everyone sat down and they waited. James, why didn't the judges read their judgment? Why didn't they let Kenyans look at their demeanor, their body language, as they said the evidence was not enough? Why? They could have taken 3 months. They could have taken 6 months. The question is this, James. Justice must not only be done, but also be seen to be done. People sat through the proceedings for 6 days, Monday to Saturday, religiously. And on this day, when the judges will come and say, this is our decision, why?
Would you want to make reductions on that?
No, I will ask. You see, I am seated here and you're asking me why we think, why my clients think that the reasons don't meet the standard of law. I am looking you in the eye and I am telling you why.
All right.
Surely, that was owed to Kenyans.
We surely will ask them that.
Yes.
But, Kethi, looking forward and looking to the future, yeah, and in terms of how we conduct our elections, given the experiences we've had in this election, one would argue and say we conducted pretty much a better election than what we did in 2007. What do we improve on in terms of registration of persons, in terms of IEBC, for instance?
Let me just say this. Kenyans have invested in terms of time and finance in their institutions. Good enough is not good enough. We have set standards. They must meet them because these are our institutions. And there's much more at stake. The Supreme Court was not made for 6 judges. It's not that we had 7 great minds that we needed to find a job for. That Supreme Court was created for the people of Kenya. The IEBC as well is an institution that belongs to Kenyans. We as Kenyans, we must say, good enough is not good enough. We set the standards and by all means, you should meet them.
And finally, as we wind this conversation down, especially on the issues of registration of, of voters, how many principal registers should we have? We have one, have a green book, and the BVI kit.
Let me ask you, there was this school, and it's in the judgment, in Kieni, in Nyeri County. It had 1 registered voter. 321 people voted. Why would IEBC carry 320 ballot papers to a polling station with 1 registered person? When the law states, the law is very clear, it states that if the votes cast in a polling station exceed the number of registered voters, that result must be nullified. But what does the Supreme Court say? It says there's a green book. Let me make it very simple. If you're having an election for the Kenya Union of Journalists, the union knows how many journalists are there. If you're standing to be chair, you know how many votes you have to win. If you walk in and there are 300 registered journalists, and when you walk out, there are 500 registered journalists, surely, isn't there a problem, James?
Clearly there is a problem.
There is a problem.
All right, Kethi.
Yeah.
Thank you very much for making time to be with us. Hopefully now you have more clients.
It's not the quantity, it's the quality.
You're not answering my question.
Not quality. You see, I was doing my job and I did it to the best of my ability, and I will continue to do my job to the best of my ability, inshallah.
Mm-hmm. I'm asked on Twitter to ask you that the opposing counsel, we read that they are posting about 400 million, in terms of what they are owed by their client. Would you shed some light? How much? Probably half of that.
I'm going to take the Fifth Amendment.
We don't have that. Not here. We don't have it.
I retrain. I can plead many things. I can say client confidentiality, professional ethics, but it's something that certainly I'm not going to say to you in private or in public, on radio or TV.
You've done well.
Thank you.
Thank you very much.
Thank you for
and
having
yes,
me.
you have been hired as my lawyer. Thank you very much.
Now I can tell you how much it costs.
Exactly. All right, we'll be speaking to Kethi Kilonzo just before we go. Well, the world has moved and changed, and well, we're trying to move on from analog and digital. In fact, our elections were about analog and digital. But really, are there things that really we can get rid of? Well, take a look at this clip and make up your mind.
Emma. 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 Emma.
All right, the paper has a great future. Kethi, you need to lose that notebook. That does it for us here on KTN LiveWire. Thank you very much for coming. Let's do this all over again next week, Thursday. I'm James Smart.